Lisa, let's start with this hearing related to the president's hush money conviction. Kind of take us back to what has transpired in this case and what we expect today.
Well, after the president's conviction, Anna, you'll remember that the president was sentenced essentially to an unconditional discharge, which is essentially no sentence at all. Notwithstanding that, this is a conviction that the president would like to see vacated. And not only is he appealing it within the New York State court system, where an argument is scheduled for June, but he is also trying to bring that case back to a federal court where he can make arguments in his own defense that this never should have even gotten to a trial because of the presidential immunity decision. His argument is not only that this implicates his official acts, but that there was evidence used at this trial that never should have been allowed. Again, under the Supreme Court's immunity decision, official acts evidence, meaning evidence of things that he did while he was president, can't be used to even prove the existence of unofficial conduct. And it's on that basis that a federal appeals court has sent this back down to Judge Alvin Hellerstein, who is hearing for the third time whether or not the president now has good cause to remove this case to federal court. When he last decided this in September of 2024, Judge Hellerstein decided in a single paragraph that there was no such good cause. Essentially, the appeals court is saying, give us more. Tell us more about why there is no good cause. And in particular, weigh for us whether it's even permissible for somebody to file this removal notice after they've already been tried in a state court, not before.
Tried and convicted. Of course, the immunity decision happening after his conviction in the state court. Duncan, you know this federal judge, Judge Hellerstein. How do you think he's going to take a look at this case for a third time?
Well, I mean, it's interesting. Look, he's been around the block a few times. He's 93 years old. And so I think that if anything, the appeals court, Lisa's right, is asking him to show his work. I mean, he needs to give more evidence of why he came to the decision he made. But for him, it's so obvious to him that that's the result, that he was able to sort of dispose of it in one paragraph. But this fight is not really about whether Mr. Trump is innocent or guilty. It's about where this case belongs. And so he's going to have to flesh it out more. I'm sure that he will comply with what the court is, the appeals court is telling him to do. But I think he's going to come to the same result, which is that this wasn't really the business of the presidency. It was the business of hiding a sex scandal. And that really gets into this test. There's this question about whether there's a federal officer removal test and whether the case can be removed to federal court, because what he was doing really was about diplomacy and enacting and executing federal law. But I think this is going to give the opportunity to the court to really lay out why this case revolves around secret payments to suppress allegations of an extramarital sexual encounter, timed to avoid public disclosure. This is not really the result that President Trump wants to get to here, having this court have to show all of the work here, because I think what the court is going to wind up doing is writing a decision that outlines how all of the money was funneled through a personal fixer and Mr. Trump's longtime private lawyer, not anyone having to do with a governmental role, that this reimbursement scheme was disguised as legal expenses, not inside his private family business, that this was driven by fear of personal humiliation and political fallout, not anything having to do with his government role. And so I think at the end of the day, this is going to be a result that is not really in President Trump's favor, to have Judge Hellerstein show his work on an opinion that he found so obvious that he disposed of it in a paragraph.
So, Lisa, this is, in a sense, about venue and about the immunity decision, right?
Correct.
So help us understand what happens after this hearing today. How could this play out?
Well, as I mentioned earlier, there is an appeal in the state court of President Trump's conviction scheduled for June. If Judge Hellerstein were to find that this case should have been removed and still should be removed to federal court, then the president would make the argument that he was immune from prosecution on the basis of A, being a federal officer, and B, having what's called a colorable federal defense, that he was immune from prosecution both because it implicates his official acts and to the extent that it was unofficial, it implicates official evidence. This is Duncan is right. This is about venue, but ultimately it's about where the president thinks he has the best chance of vacating this conviction. His best outcome here is that Hellerstein grants removal, and therefore that he can sort of appeal his conviction within the federal system, not the state court system. But I think he's also right that really what the appeals court is asking Judge Hellerstein to do is to show his work. When I look at that old opinion of his, he says in a cursory way, nothing in the Supreme Court's opinion affects my previous conclusion that the hush money payments were private, unofficial acts outside the bounds of executive authority. I don't think that conclusion is going to change. I think he's going to have to lay it out in a more laborsome, fulsome way for us all to read. And I'm not sure, to Duncan's point, that the president will be well served by that.
I'm only laughing because I think of my children and their, teachers telling them to show their work. You may have arrived at the right answer, but how did you get there? I'm coming to you in just a second, Mark, but I do want to ask one follow-up question to you, Duncan, because when the Supreme Court issued that presidential immunity ruling in 2024, there were a lot of open questions on what constitutes an official act versus personal. If this case makes its way to the high court, because we know appeal after appeal after appeal could land there, do you think we could see some clarifications on what an official act is?
I think the answer is nobody knows, and that is what President Trump is clearly trying to do. He feels like he has a control over these federal judges in a way that he doesn't over the state judges, and over the Supreme Court of the United States in a way that he doesn't over the state judges. And as Lisa says, his best outcome here is to try to bring this to the United States Supreme Court and make some colorable argument and find 5 judges or justices of the United States Supreme Court who are willing to go his way. I mean, the law of the United States is whatever 5 justices on the Supreme Court say it is. And so, he's had a lot of luck during his second term with the United States Supreme Court. He's hoping that his luck will continue. And all he really needs to do is get into the federal court system somehow. That's what he's trying to do. And so the answer is it shouldn't. I mean, I think it's such an obvious issue to Judge Hellerstein that this cover-up is about false invoices and ledger entries and false checks tied to a private company. It didn't have anything to do with diplomacy or national security or executing federal law. And so I think it's such an obvious issue to Judge Hellerstein that, again, he's able to sort of swat it away with a paragraph. If you get up to the United States Supreme Court on it, it's anyone's bet what happens.